Good afternoon, drivers, and welcome back to Inside Trucking. It's Sunday, September 28th, and this is going to be our regular new date and time, Sundays at 12 o'clock noon Eastern Time. So we hope that you'll be tuning in from this point forward. Same trucker time, same trucker channel, okay? So today we're going to talk about, this is episode 5, by the way, and today we're going to talk about the Pink Cheetah lawsuit. We're going to talk about Pink Cheetah Express, LLC versus Total Quality Logistics, LLC, TQL. And many of you have been following this lawsuit, and we got some news earlier this month in reference to the status of that case. The lawsuit was technically dismissed by the federal court on September 12th, but that does not necessarily mean that that this is all over. So this episode is actually entitled Pink Cheetah Poised to Pounce Again. Dakota versus Goliath, right? So if there ever was a Goliath in the logistics industry, boy, does TQL satisfy that, that claim to fame, second only to C.H. Robinson, but the number one privately held brokerage in the United States. So let's talk about the controversy. Let's talk about the lawsuit. Let's talk about what we expect is going to happen from this point forward, because like I said, Pink Cheetah doesn't seem to be ready to roll over anytime soon. So we can probably expect an appeal. In fact, Dakota herself has told me she does intend to appeal. So let's start with the controversy. So what is this all about? Well, this case is a case about broker transparency. And for those of you who have been following that issue, you know that SBTC sparked a renewed interest in broker transparency back during the COVID era, May 6th of 2020. We filed the first petition asking for FMCSA to strengthen broker transparency, and OIDA followed after that, and a whole bunch of other groups within the last few years have joined the bandwagon and have told FMCSA they support broker transparency and strengthening broker transparency, so there's actually teeth to the existing rule. And keep in mind that rule has been around for like 80 years or something like that, 75, 80 years, something like that. And I think, it's not something new, broker transparency. It's grounded in ICC regulatory wisdom, going way back, I think it was 1949, I want to say, the first rules that had to do with broker transparency. And then after the Motor Carrier Act of 1980, even though trucking got deregulated, they did not deregulate brokers. And in fact, the current 371.3 that we know today was an outcome of the Motor Carrier Act of 1980 during the Jimmy Carter era. So let's talk about this. Now, this boils down to a relationship between Pink Cheetah Express as a duly authorized motor carrier at the time, and TQL as a freight broker. And it goes back to June 10th of 2019. That's when the contract was signed between Dakota and the folks at TQL. And the nature of that contract is what is at issue here. And it has to do, of course, with this ongoing issue, not only with TQL, but other brokers, TIA being the champion for that side, right? The big brokers, Transportation Intermediaries Association. But let's talk about what really has gone on with respect to the last couple of years under that June 10th, 2019 contract between Pink Cheetah and TQL. So in January of 2023, so we're going back now 2.5 years or so, Pink Cheetah, under that contract, hauled a load of ice cream for TQL. an interstate load of ice cream. And it was pursuant to the contract. And so what happened is after Dakota hauled that load, with all the discussions about transparency at the time, going on, she said, well, maybe I should ask TQL for transparency. So she did that. And so she said, pursuant to 371.3, under my rights to transparency as a motor carrier, and pursuant to your record-keeping obligations, which go back 3 years, I want you to please produce your transactional records, because I'm a party to that transaction on the broker carrier side. She asked to see the transactional records between the broker and the shipper of that load of ice cream. And so TQL did what I suspect they regularly do, and that is they said, nope, we're not going to give you any transparency. We're not going to give you any records pursuant to 371.3 because you, Dakota, waived your right to receive that when you signed the contract. And so she did not like that response, of course. And so the question then became, this is what we brought up in 2020, in May 6th of 2020, the question remained, does a regulated entity, a freight broker, have the right to trump a regulation through contractual waivers, right? That's the issue. And of course, SBTC and all of our allies say they don't, and we have asked for FMCSA to take that position and to strengthen the regulations to make that perfectly clear, basically prohibit those waivers. And OIDA has asked for that as well, 10 days after we did back in 2020. And basically, that is the issue. Is that a legitimate thing? Can a broker actually do that? And in the world of, administrative law, right? As I understand it, I'm not an attorney, but as I understand it from having taken administrative law classes in grad school, there's a hierarchy here. There's a structure. And the hierarchy is, nothing, of course, is more important in the world of law and regulation than the United States Constitution, right? And then there's laws. There's actual statutes, federal law in this case. And then there's regulations, right? The laws are made by Congress, signed by the president. I'm just a bill, remember that. And then, the regulations are made by the administrative agencies, but, they're like the fourth branch of government, right? The bureaucracy. But they have the full force and effect as if they are law, right? So usually Congress passes a law that says that they have the right to promulgate regulations through the rulemaking process. That's the enabling legislation, as we call it. And then the agency can promulgate such rules under the Administrative Procedure Act and its own department regulations, and issue rules after public notice and comment rulemaking. And so that's what we asked for, new rulemaking. And so after that, then comes contracts, then comes contract law. So Constitution, federal law, administrative agency regulations, and then contracts. And so what TQL and a lot of other brokers have done is they have somehow taken it upon themselves to deregulate themselves. So if they don't like a regulation like transparency 371.3, they just put it in their contract, and they say, well, the parties under the contract agreed to not abide by that regulation, as if that's okay, and that's not okay. And so that's the bone of contention that we have here. And any lawyers at TQL that wrote this waiver that deregulated them through the contracts and tried to void out a federal regulation, they either know or they should know that they can't do that. They all went to law school. This is not rocket scientist stuff. This is all very clear. So, and I'll prove it in a minute with a court case. So let's take a look at what transpired next. So Dakota went to a prominent attorney in Washington, D.C., who happens to be the attorney for the SBTC, Lawrence Soshi. And Mr. Soshi took on the case, and he issued a cease and desist letter to TQL on May 1st of 2023. And they did not respond, as I understand it, in a favorable way. And so Dakota then came to the SBTC. And we listened to her story, and we listened to her argument, and it aligned with our policy positions on broker transparency and waivers and the like. And so on May 7th of 2023, we went to TQL's trade group, the Transportation Intermediaries Association, and we attached a copy of that May 1st cease and desist letter, and we filed an ethics complaint. Now, I have filed ethics complaints with TIA before, and I know how to do them. I know what the policy is. You don't have to be a TIA member to actually file such a complaint. So we did that. And 2.5 years later, we still haven't heard back from TIA on our request for them to enforce their own code of ethics against their member, TQL, with respect to this issue of broker transparency. And in fact, we even pointed out that TIA has a model contract, which you would think would evidence their position on best practices. And guess what? Waiver clauses are not in the model contract. So we made what we thought was a good argument. It's unfortunate that they just decided not to answer. But actually, they did answer. They answered by issuing to me personally a cease and desist letter, which we got. And when we stopped laughing at how ridiculous it was, we wrote back to them and we said, you can, take your cease and desist and you know what. And that was the end of them ever writing back to us. So they never addressed our complaint. They did not hold TQL accountable to their own code of ethics. That's the type of organization Chris Burrows is running at TIA. All you members, part of FreightX and the like, TIA delivers, hashtag, you must all be so proud of your organization that has a fake code of ethics and doesn't enforce it. Okay, I hope you get so many more members who sign up for your organization, Chris. So anyway, here's what happens. After that fiasco in May, then Dakota, with the help of SBTC, writes a complaint to the Secretary of Transportation, at the time, Secretary Pete. October 31st of 2023. No tricks, no treats. Basically, a straightforward request for an investigation and a request for the U.S. DOT to enforce its own 371.3 policy and go get her documents that she has a regulatory right to under federal regulations. And so many times people file complaints and they're deemed as not worthy, they're ignored, but not this complaint. Not this one to the secretary. Oh boy, this got designated as VIP apparently, and sent down to FMCSA for investigation, review. There's some discussion about what exactly it's called, because we had some fun with FMCSA with a FOIA request, and we said, send us the results of that investigation, and they said, we got nothing. And we said, what do you mean? So we already have some things. What do you mean you got nothing? And they said, well, you asked for the results of the investigation, but it wasn't an investigation. So we came back and we said, okay, how about results of the review? Would that get us the documents? And lo and behold, they said, yeah, the review. That's what we did. Yeah, that's the ticket. So they sent us the documents, right? Okay, so she files this complaint with Secretary Pete, goes to FMCSA, and it's assigned to a transportation specialist by the name of Nelson Newcomb. And so he makes contact with TQL. He says, we got this complaint, and we're here to ask you to send us the applicable information that you're required to send to Dakota, under 371.3. Now Dakota's not asking. Now your regulatory authority, U.S. Department of Transportation, is asking, and you have to comply. And so after some back and forth, and the legal department, saying to them, oh, we're not sure if we have to comply, and blah, 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 blah. Eventually, there was even some controversy about, whether they were going to go in and seize the records because it was taking so much time. And we were led to believe that happened. And now it turns out it appears that never did happen. But, it may have been clear that was coming next. And so TQL complied. And so they gave the records that were being requested by Dakota on that January 2023 load of ice cream with respect to the contract between the broker and the shipper, right? So basically the invoice or the numbers that are on the invoice that, Dakota could then take and say, okay, I know what I got paid and I know now what the shipper paid. Ergo, I can do the math and I can compute what TQL kept as a commission. They would call it margin because they don't like to talk about commissions because they don't like to pretend. They like to pretend that they're not like other brokers, like real estate and stock brokers and insurance brokers, who all do talk about their profits in terms of commission. But that's another story. We'll talk about that another time. Under a different program. So she gets the documents, she gets the data, and she computes the numbers. Now, at first, this number of 44% starts to circulate. That's how much allegedly TQL kept as part of the take, right? There's these organizations that are out there, right? TIA, 5 years ago, remember him? Remember Voltman, who was the head at that time? Bob Voltman, and he said, our average broker margins are 16%, right? And then as this is all going down, in like December of 2023, there's Ken Adamo at DAT. Now broker average margins are 14%, right? And we've done another show on that already, episode 2. You should go watch with respect to gross margins versus net margins, right? And how there's a game that's being played by Freight X, smoke and mirror, shell game, all sorts of stuff. So the 44% figure comes out and starts to circulate, and there's some other videos that are out there, and they're doing their best to go with the information that has been circulating. But we got all the records ourselves through a FOIA request, right, directly from FMCSA, and so we analyzed all the records. And so it turns out on this particular load there was a lumper involved, right? So you can't just look at what Dakota got and what the shipper paid and assume that the broker took, the rest, because a lumper was paid as well. But when we did all the math, it came out to like 39.5 or something like that that TQL actually realized in margins, in profits, commissions. I'm going to keep saying commissions. After all was said and done. So, you should know that it's really a 40% commission, right? But that's not 14%, Ken, and that's not 16%, Bob, and now Chris, right? Ken Adamo, within the last 30 days, it's 12.5 now. It's 12.5. Yeah, sure it is. 40% commission, right? So this was just one load. This was just broker transparency with respect to the big brokers who were doing these waivers. This is the first one that came down the pike, and it happened to be 40%. Wow. It must have been a fluke, right, Chris, right, Ken? I mean, we can all do the math, and it just must be, an anomaly, right? This isn't what's really going on. 12.5% is what's really going on, right, guys? Yeah, sure. Okay. So we're not gullible, we're not dumb, and we know that we are just at the tip of the iceberg. In fact, Dakota knew that. So after she gets the documents, it took about a month, right? So she gets the documents around November 29, November 30th, like around that time frame of 2023, and then Dakota says in December She says, well, there's 14 more loads that I did for them, and I want transparency on those as well. So she goes through the process again, and she contacts them, and she asks for the information. Now, something had happened that she didn't know about yet. And a lot of people are not picking up on this because this is a matter of what did you know and when, right? So we'll come back to that, but just think about that there's something that happened that she doesn't know about yet, right? So she just goes on, and she actually goes with the flow, and she says, well, I got one, now I want the other 14. So she puts in like a supplement to her complaint, right? She first filed a complaint directly with the secretary, a letter, and then they had her go through the complaint database. So now she's supplementing her complaint on the data, the database. And she's saying, now I want 14 more. Thank you very much. May I have another? Basically. And so now that request gets assigned to a different transportation specialist. And now we start to see some crazy things that are happening at FMCSA because it looks like there are decisions that are being made that are, on a whim, that are not following, clear administrative procedure, and it's arbitrary and capricious because Nelson said yes, but the new guy, Zach, he said no. Now, there's something that happened where it triggers an obligation. It's actually a duty on behalf of the Department of Transportation. Nobody's really talking about that yet because that issue has not come to fruition because it has to do with what FMCSA owed to Dakota, what level of diligence that they owed under their duty. And so and I don't think this is on the radar at the moment, but because of that arbitrary and capricious handling by this guy Zach, in our opinion, compared to Nelson at FMCSA, Dakota has a case against the Department of Transportation. She has a case against FMCSA. And in fact, that duty that I'm talking about is triggered under federal law so that when somebody from the Department of Transportation makes a demand for records under that law, which Zach did, in that case, then if they don't comply, there are certain things that the Department of Transportation is required to do. They're required to compel the regulated entity to comply. Zach didn't do that. And in fact, Dakota pointed that out. Dakota's lawyer pointed that out. Nobody at FMCSA during the Biden administration did anything about that. And the clock is still ticking, but statute of limitations on that has not run out. So that's something that FMCSA should be thinking about, especially in terms of the rulemaking that they're currently engaging in now, right? The property broker transactions transparency from November 2024 is now being redone. We're not sure what that's all about. Cans being kicked down the road to May of 2026. Second notice of proposed rulemaking coming. We sure hope it's going to be stronger than the first one and not diluted like SBA and TIA have collectively, tried to convince DOT to do. Collusion. But Secretary Duffy's recent tweet from like a week ago, where he said to a trucker in the field, we're going to do transparency and we're going to make brokers be upfront, right? That's out there now. So we have high hopes. But anyway, so there's an issue with FMCSA dropped the ball, and they were required the second time. Once they started the process, which they did, they knocked on the door, then they had to go through the door. And if they didn't open the door, TQL, FMCSA has an obligation to break the door down in figure of speech and go and get the documents, right? So that's still an obligation, and we're going to have some discussions with the new administrator about that, presumably Derek Bars when he comes in. But in the meantime, something happened. I'll come back to that. Now, it's December of 2023. She makes that request for the 14 loads. They say no. They ignore her. They block her. They stop her from even communicating. She goes to Mr. Sochi, and he tries to get him, and so So we kind of hold off there, in the spring of 2024. And nothing really significant happens, other than Dakota puts in a Freedom of Information request with FMCSA for all records associated with that complaint. And before the rulemaking comes out, right? It was supposed to come out in October of 2023 or 2024, and doesn't come out till November of 2024. After the election, they saw who was coming back, and at that point, her FOIA request is still being processed, right? And then they start to give her records right after they issue the rulemaking. And in fact, I think there was a couple of waves of records, and they give her in January of 2025 now an email, a letter, a directive, an order. Pick your, choice of words, what you want to call it. But it did go from Nelson Newcomb on November 30th, 2023, as he was closing out his report to his superiors. And he clearly, no question about it, directed TQL to comply with the 371.3 regulations moving forward. And he said, take that waiver out of your contract. Now, there's a game going on here in this case. And the game is that email an order? Is it a directive? Is it a guidance? Right? That's the key point in this case up until now that has resulted actually in the dismissal. And we'll get to that in a moment. But what you need to look at here is that at the time that Dakota gets this email, it's the first time she's ever seen it. She didn't get it as a result of the process, of the complaint process. That was a private, secret email up until that point to TQL from FMCSA directing them to comply with existing regulations. It's not kind of like, a friendly reminder. It's, listen, you need to follow the regulations, and you need to take that waiver out because it may constitute evasion of regulation. Now, why is this significant? Well, I don't even know if the judge knows yet how significant this is. I suspect the appeals court is going to learn real quick. But what's significant about this is you have to go back to the October 31st, 2023 complaint to Secretary Pete. What did Dakota ask for? Well, she asked for the records that she was entitled to, but she also asked for an order from the secretary. And in that order, she asked for the broker, TQL, to be ordered to comply moving forward with 371.3 for everybody, including her. And then she would wind up, coming back at them again, and after they were already ordered to comply, and they would say no in December of 2023, and to remove the waiver from the contracts because they're not allowed to deregulate themselves, right? And so what appears in that final recap report and the order, I'm going to call it an order, to TQL is exactly what Dakota asked the secretary for. I got my records. I got a directive from FMCSA to TQL that says that they have to take the waivers out, and they have to comply moving forward for all carriers that file requests for transparency under 371.3. Now, she didn't know it at the time, right? But she got it. So when you look at what she asked for, and then you look at what they issued to TQL, albeit secret and, private, then she got what she asked for. You have to say that she asked for an order, and the things that they told TQL to do were the things that she asked them to tell in an order. So if it looks like a duck and it quacks like a duck, guess what? It's a duck. Now, Pink Cheetah and Sochi and the like have all made the argument that it is an order, that email. And it's an order because the Administrative Procedure Act defines what an order is, and it qualifies for an order. It's at the result of a administrative proceeding of some sort, and it's the final determination, the final directive. Qualifies as an order, no question about it. Now, no disrespect to the judge, because I know she's busy, with other cases and dealing with illegal immigrants being deported and all that stuff. But when she focused on this case for the 12 minutes that she did, it appears that what she did was she missed what Dakota had asked for, and she missed the definition of what an order is and how what the agency issued qualifies as an order. Any attorney, should be able to read that definition and say, yep, looks like an order to me, right? Including any judge. So there's a question about, whether she missed that. And but we'll talk about her ruling in just a second. Now, when Dakota gets this particular email through FOIA, now she says, so I asked for an order. Privately, they sent them an order, and they didn't give it to me at the time, but now I got it. Now, I went to FMCSA when I heard about this, and I said, what's going on? I said, Larry Minor, come on, explain this to me. Why would you withhold that document that was the very resolution she was asking for in her complaint from the complainant? Why would you do that? And so Larry came back and he answered. He doesn't always answer me, but in this case he did. And he said, well, James, he said, there's communications that go from the agency to particular regulatory entities and regulated entities, and they're not meant for public consumption. It's just a directive, private communication, between us and the agency. And he said, but when somebody asks for that stuff, even though it's our procedure not to give it out to the complainant, under FOIA, we have to give it. And so we didn't want to give it up, but we had to. And so that's how she got it. So keep in mind that, folks. They're not always going to give you what you should get unless you ask for it in a formal way through a Freedom of Information Act request. So that's a footnote to this. All right, so now she has the document. She says, So they were directed on November 30th to remove that waiver from that contract and respect 371.3 moving forward. Well, December is after November 30th, right? It's moving forward. And so when she went back at them, it turns out, and she made the request for the 14 more loads, they were supposed to give it to her, not only because there's a regulation, but because FMCSA had already said, yeah, your waiver's not enforceable, you should take it out. And they said, essentially, that, we're going to remind you of your duties, right? That you still have to comply with 371.3 after we had to go fetch the document because you wouldn't give it up, as you're required to do pursuant to carrier's rights to the documents, right? So now she gets really pissed because she's like, wait a minute. So when I asked in December, you mean they had already been ordered to do what I asked them to be ordered to do, to respect moving forward for all carriers? So then she sues. And so she filed her lawsuit after sorting through this in January on February 25th of 2025. For those of you who are, experts in looking up federal cases and you use that pacer.gov system, the case number is 1:2025 CV 00552. Again, 1:2025 CV 00552. The Honorable Judge Sparkle, right? Presiding. And so she files the complaint, and she basically says, it's a very clear-cut complaint, and there's a lot of people that are out there, there's lawyers that are on, social media and YouTube and all, and the lawyers for TQL, everybody's trying to spin this this case into something that it's not. So let me start by telling you what it's not. It is not a request for the federal court to enforce 371.3. No matter how many times TQL jumps up and down and tries to pretend that that's the case, that is not the cause of action. That is not the complaint. The complaint is that once there's an order that is issued by the department, then if the entity doesn't comply, then the secretary can sue that entity. The secretary can go to the attorney general and ask them to sue the entity. Or there's a private cause of action in the law that says the person who's filing the complaint with the government agency has the right to enforce the order that wound up being issued in response to the complaint by the DOT. So that's the avenue that she goes, right? And so that's her cause of action. And so she says, I still would like those, those 14 loads, but I'm not asking you to enforce 371.3 per se. I'm asking you to enforce the order where the secretary, through FMCSA, told TQL you have to respect and provide the documents under 371.3 moving forward. You always had to do it, but now we're ordering you to. At least that's the way I read that document, right? So now, after the complaint is filed, of course, then it's TQL's turn to go, and they file a 26-page motion to dismiss. And that was filed in April 4th of 2025. And they basically throw everything against the wall to see what'll stick, right? So the first thing that they say is that email was not an order, right? And then they say, under the contract, again, June 10th of 2019, between the two parties, Pink Cheetah and TQL, contract disputes are required to be filed in Ohio. And so this is the wrong venue, this federal court in Washington, D.C. Judge, it should be in state court in Ohio. And, Pink Cheetah winds up responding to all of this. She goes one more time on April 25th. And so, the arguments, the counter arguments, now come out. And, Pink Cheetah says, listen, that's if there's a contract dispute. This is not a contract dispute. This is a specific federal action that is asking a federal court to enforce a order of the secretary. The contract's irrelevant. It doesn't matter how that order came to be. It's just Pink Cheetah says, I have a private cause of action under the federal statute. There's an order. It came via email. And she says, it's clearly federal jurisdiction, and Washington is appropriate because by then she had transferred all her operations on company snapshot as far as her USDOT, active USDOT number goes, to Washington. So, and they TQL, through other things. She has no standing because she's not currently a motor carrier. So after brokers like TQL put her out of business in the interstate transportation, of regulated commodities under authority, her authority couldn't pay the insurance anymore, and her authority lapsed. And so she moved her operations from inter to intra, and then she could do anything that's exempt commodities under her DOT number with no authority, private carriage. Florida doesn't regulate for hire, so she could do intrastate for hire of what would normally be regulated commodities. So she wasn't out of business. She was just out of the interstate authority, motor carrier business. And so here they are saying that something that happened in January 2023 when she did have that federal operating authority, now she can't sue because she no longer has that authority. I mean, that was nonsense, right? No standing. She has standing because she had the right to file the complaint. And everything stems from her rights pursuant to 371.3 on the load that she hauled for them in January, ice cream 2023, that was pursuant to her operating authority. In fact, the broker would be in a lot of trouble if they hired her and she didn't have operating authority. So they know she had authority, right? And so, they throw this typical language, there's no cause of action. She waived her rights in the contract. And the contract is just not relevant to this, case. It's about asking the court to enforce an order of the secretary. They say there's no private cause of action for 371.3, as if she's suing under that. She's not. So failure to state a claim is basically what they suggest. Now, takes a few months, right? And the judge goes through all this stuff. And then finally, on September 12th, a couple of weeks back, the judge issued a finding. And the judge basically said, look, we're going to start this with one issue, and we don't need to go any further on all these other things TQL has said. She says, the question is the email an order? And so she concluded it was not. And so she dismissed the case. She said, we don't have to get to the other issues. Now, I think she's wrong, and I know Pink Cheetah thinks she's wrong, and I'm pretty certain Ms. DeSochi thinks she's wrong. So she is, as I understand it, filing a notice of appeal, and then there'll be a briefing schedule, and then we'll see these two go at it again, Pink Cheetah and TQL. But there's something very important and worthwhile pointing out at the very end of this 8-page decision that Judge Sparkle issues. And that's a footnote at the bottom of page 7. So you go into Pacer and you look up that case number and you pull the decision, you'll see the following. And I'm going to read this verbatim because, boy, is this powerful. And, I can't imagine how TQL feels reading this because they won, yet boy, did they just get scolded by a federal judge as to what they're doing. The judge is basically saying, I wish I could stop you, but I can't stop you the way I was asked to stop you. Now, we think she's wrong, and I think the appeals court will probably tell her that and remand it back to her. But she is not on TQL's side, folks. And that's why you don't hear anybody, applauding on the other side, Freight-X. These guys are nervous. They're scared. They're worried about what's going to happen next. And quite frankly, in addition to an appeal, there could be another lawsuit down the pike. Statute of limitations is still running, and it's not over. So who knows, what's going to happen here. But the judge tells Pink Cheetah what she has to do in order to win, at least in her court. So get a load of this, right? It troubles the court, so as she's dismissing the case for no cause of action, quote, it troubles the court that regulated entities may attempt to evade regulatory obligations by embedding waivers in contractual agreements. Bam! Holy moly cow! What did she just say? She says, I'm not saying that TQL didn't do it, or I'm not saying the TQL did it, but they did it. That's what that says, right? I mean, everybody who reads that knows that. She's saying, boy, I really wish I could have slapped you upside the head, Mr. Oakes, but didn't come in exactly right. Then, in the same footnote, she tells Pink Cheetah how to do it. She says something to the effect of, and this is not a quote, other courts have suggested a duly promulgated regulation may serve as an order that gives rise to a cause of action. So she's basically saying, why don't you go back to the drawing board and argue that the email is an order, is not the issue. The rule is the order, the regulation. And so that opens up a whole nother cause of action that could come down the pipe. Not saying that it is, but There's a whole bunch of different avenues that Dakota can go here. Appeal this case, do another cause of action based on the judge's opinion, go after FMCSA for not making them give the records, TQL giving the records the second time. A whole bunch of things. This is not over, folks. It looks like this has just begun. So now, what does that remind you of, that quote that Judge Sparkle says? Well, it reminds me of a court case where the court said you can't use your contracts to get out of regulatory obligations. And where did we see that? In the November of 2024 rulemaking by FMCSA on property broker transactions. I'm getting so excited here. I can't get this out fast enough, right? So in that rulemaking, FMCSA says, quote, a regulated entity must adhere to the regulations and cannot, quote, from the court decision, disguise its regulatory obligations as contractual ones, end quote, right? Citing in a 2020 case, Taylor Energy Company versus United States. So, boy, everything points to, TQL is wrong. They can't do what they're doing. And boy, is this issue ripe for further litigation. And I suspect that is going to be coming relatively soon.